Welcome. In this video, we will discuss about the Supreme Court decision to discourage the use of Article 32 in scribe cases. So basically, there are many cases which has been presented in front of Supreme Court under the Article 32. So in this particular video, we will discuss about the Supreme Court decisions, which it says that it's going to discourage the cases coming directly to it under the Article 32. We will discuss about the Article 32 in detail. We will also discuss what exactly are writs and what are the different types of writs which are provided in our Indian Constitution. Then we will discuss about the Article 226, which is in regard to the High Court. So let's begin. So the first thing that we need to know is the Supreme Court decision. So Supreme Court said that it is trying to discourage the use of provision under Article 32. So this is the judgment which came in that it is going to discourage the use of Article 32 that allows the incarcerated people to directly approach the top court against the violation of their fundamental right, as it felt that the high courts were well equipped to deal with such matter. So the idea, the logic behind the Supreme Court judgment to discourage the petitions coming under the Article 32 is that they need not to actually dwell with all the questions of Article 32, because very well the high courts of the states are equipped well enough to take care of such kind of petitions. So that is why Supreme Court has said that it should go to High Court instead of coming to the Supreme Court directly. So it in a case pertaining to Malayalam journalist who is facing charges of sedition and offence under the OPA, which is your Unlawful Activities Prevention Act, and who is being probed by the Uttar Pradesh police for alleged linked with band outfit Popular Front of India. The SC said it was trying to discourage the use of Article 32. So basically this is the case in which the Supreme Court has said that it is going to discourage the Article 32. Now from the context of your UPSC, you actually don't have to delve deep into what the situation was all there, why this journalist was booked. He was going to the Hathras village where the gang rape happened and the tussle with the police over there. You don't have to delve in all the political context of that particular decision, but try to stick to the power of Supreme Court in this particular regard. So Supreme Court has said that it is trying to discourage the use of Article 32. In another case also involving a person who is currently arrested in multiple criminal cases for his tweet on Maharashtra Chief Minister, Supreme Court declined to entertain a petition under the Article 32. So again, this is not the only case where the Supreme Court has talked about not using its power under Article 32, but a similar case of its petition against the criminal who was charged with tweeting against the Chief Minister of Maharashtra. Supreme Court there also have declined the petition. The Supreme Court was of the view that High Court can also uphold the fundamental rights and grant bail. So approaching Supreme Court under the Article 32 was unnecessary. So we all know that the cases, the pendency of cases by the court is a big problem for the judiciary system in India. In that regard, Supreme Court is already loaded with a kind of petition. It has to work on the constitutional bench, the question of constitutional validity. So in that regard, it says that such kind of cases could go to the High Court before coming to the Supreme Court directly. So in this context, let's try to understand what is exactly the Article 32 is. So Article 32 is actually Part 3, which deals with the fundamental rights in our Constitution. So it is the Article 32 which is present in the Part 3 of our Indian Constitution. What it is about, it states that the individual have the right to approach the Supreme Court seeking enforcement of other fundamental rights recognized by the Constitution. So basically, if you remember in your Lakshmikant, you might have wrote B.R. Ambedkar, the one who drafted our Constitution. He said that Article 32 is actually the heart and soul of the Constitution. Why? Because think about it, without Article 32, all the other fundamental rights are of no use, because you cannot go to the court for the violation of any other fundamental rights. So, right to constitutional remedy, B.R. Ambedkar remarked it as the heart and soul of the Constitution. So this is the particular article which Supreme Court was talking about. In this, what happens if your fundamental rights are getting infringed, you can directly reach to the Supreme Court. The right to move the Supreme Court shall not be suspended except as otherwise provided by the Constitution. So just remember that Article 32 cannot be altered by any government, and this is again one of fundamental rights from the basic structure of our Constitution and cannot be amended. And it cannot be suspended by any government also unless or otherwise specifically provided by the Constitution. In case of enforcement of fundamental rights, the jurisdiction of Supreme Court is original but not exclusive. What does it mean? That Supreme Court could be reached out in the first instance itself, which means if there is a case, you can directly reach out to the Supreme Court, but it is not exclusive. What does it mean? That High Court also has the similar kind of power. So it is not exclusive but original. The exclusive power of Supreme Court, for an example, includes its power to hear the cases between center and states, for an example. So that is its original and exclusive power. Hearing about the petition under Article 32 is original but not the exclusive right. So just remember that this is actually concurrent with the High Court. The Constitution provides that the President can suspend the right to move to any court for the enforcement of fundamental rights during the national emergency, which means that under Article 359, Article 32 could be suspended. So whenever there is a case of national emergency, Article 32 could be suspended. In fact, before the 44th Constitutional Amendment Act, which happened in 1978, any fundamental right could be suspended, but after the 44th Constitutional Amendment Act, Article 20 and 21 could not, Article 21 couldn't be cannot be suspended, which is your right to life. Right to life cannot be suspended even under the case of national emergency, but Article 32 can. So just remember that in general situation, Article 32 cannot be suspended by any government by utilizing any power apart from the situation of national emergency, where the President can suspend it, and that power is actually conferred to the President under Article 359. Just remember that. Now let's move forward and try to understand the type of writ. So basically, a person who is engraved or who is fundamental rights are hampered, they could reach out to Supreme Court and they could file writs. So there are 5 type of writs which are basically discussed in terms of polity in the Indian judiciary. So the Constitution empower the Supreme Court and High Court to issue orders or writs for the following types. So it is habeas corpus, certiorari, prohibition, mandamus and quo warranto. We will discuss about those, what kind of details do they entail in the upcoming slides. So let's begin. So your habeas corpus and mandamus writs. Let's first try to understand these two. So habeas corpus is a writ that is enforced to protect the fundamental right of liberty of an individual. Just remember, it is called as the bulwark of the individual liberty against the unlawful detention. So just in case anytime a person is unlawfully detained, the Supreme Court could issue a writ of habeas corpus, which is actually, if you think about it, this is to sustain the individual liberty of an individual. This remand commands a public official to deliver a detained person in front of the court and provide valid reasons for the detention. So this is what, so if habeas corpus writ is issued, it means that person who has been detained need to be present in front of the magistrate, and the public official who have detained him need to provide a valid reason that why they have held him. So this kind of writ is actually, if you think about it, is the bulwark of the individual liberty. However, this writ cannot be issued in case proceeding in for contempt of a legislature or court. So just remember this this point that habeas corpus cannot be issued against the cases in which a person is convicted of the contempt of court or contempt of legislature. So apart from that, it could be issued for the public official as well as for private individuals as well. Now let's try to understand another type of writ, which is your mandamus, which is issued to a subordinate court, an officer of the government or a corporation or other institution commanding the performance of certain acts of duties. So basically, if a particular subordinate court, officer, a corporation or any other institution is not performing their duty, mandamus could be issued against them. Unlike habeas corpus, mandamus cannot be issued against a private individual. So just remember this point that habeas corpus could be issued against a private individual also, but mandamus cannot be issued against a private individual, which means the court cannot direct a private individual to perform its duty. But the government officials are very much under its ambit. The right to mandamus can be used in order the completion of a task, or in other case it may inquire an activity to be ceased. So basically this is the ambit of mandamus, that it can be used to complete its task. So basically if an officer is mandated to perform his task and he is not performing for any reason, this mandamus writ could be issued by the court. So these are two writs that we have discussed so far. Let's move forward and discuss the other two, which is prohibition and certiorari. So certiorari is issued to a lower court directing that the transfer of a case for review, usually to overrule the judgment of the lower court. So basically the higher court could actually issue a writ to the lower court that it transfer the case for review. In most of the cases, it generally to revert the judgment which was done by the lower court. The Supreme Court issues the writ of certiorari in case the decision passed by the lower court is challenged by the party. So when a party challenges that the decision or the judgment taken by the lower court is not justifiable, in that case Supreme Court could issue a writ of certiorari. It is issued in case the higher court finds it a matter of over jurisdiction or lack of jurisdiction. So these are the two conditions in which the certiorari writ is issued by the higher court, is that it found that either the lower court has gone ahead and overstepped its boundary of jurisdiction, or there is a lack of jurisdiction itself, that the lower court didn't have the jurisdiction on that particular type of case at all. So in such scenario, Supreme Court issue a certiorari writ. Let's talk about now the prohibition writ. So it is a writ issued by a higher court to a lower court to enforce inactivity in a jurisdiction. So just remember, in case of prohibition, the higher court, before the judgment itself, before the party actually challenge, as in the case of certiorari, the higher court could actually ask the lower court for the inactivity, that you are prohibited to do anything about that particular case, for an example. It happens only in case the higher court is of the discretion that case falls outside the jurisdiction of lower court. So for an example, if that's like a hypothetical example, let's suppose that the state and center, an issue which involves the parties as the union and state, they went to a district court. So we know that such kind of cases cannot be heard by the lower court, and it has to be go to the higher court. In that particular situation, the higher court could actually issue a prohibition writ, which means that the lower court is not supposed to take up the case. Writ of prohibition can only be issued against the judicial and quasi-judicial authority. So just remember, the prohibition writ is actually about the judicial and quasi-judicial authorities only. It cannot be issued, for an example, against a government official or administrative or legislative individual. So in that regard, prohibition and is only supposed to be issued against a judicial or a quasi-judicial authority. So these are the four writs we have discussed so far. We discussed about the habeas corpus, we discussed about the mandamus, then we discussed prohibition and certiorari. Now let's move forward and discuss about the last type of writ which is mentioned in our constitution, which is quo warranto. Quo warranto is issued against a person who claims or usurps to a public office. So basically, if a person who is not qualified to a particular position, if that person has got to that position, in that regard a quo warranto writ could be issued against him. Through this writ, the court inquires by what authority the person support his or her claim. So, under what qualification or under by what authority were they able to get to that position. This writ prevents the illegal assumption of a public office by an individual. So, a person who is not qualified enough to hold a public office will not be able to get that position. So, this kind of right is actually protected under the covariant writ. Another thing to know over here is that this writ does not require locus standi, which means not only it is not required that the victim issue the petition to the court. It could be like the petition could be filed by anybody. So locus standi is not required, which means it's not like only victim could file the case, but it could be filed by anybody. So these are the 5 writs which are mentioned in the constitution of our India, and under which the Supreme Court as well as High Court both have the concurrent power to issue all these 5 kind of writs. So let's try to understand now what is the Article 226 and why the Supreme Court is asking that the power mentioned under the Article 226 should be utilized first before the Article 32. So Supreme Court has ruled that where relief through the High Court is available under Article 226, the aggrieved party should first move the High Court. The reason behind is mostly that Supreme Court is also understaffed and overworked. In that regard, if relief could be provided by the Supreme Court, then the party should first reach out to the High Court. In case of the enforcement of fundamental rights, the jurisdiction of Supreme Court is original but not exclusive. We did discuss about it. It is concurrent with the jurisdiction of High Court under Article 226. So it shares its power, or the High Court under Article 226 also has the similar power. Recently, the Supreme Court also conveyed its concern that in many matters involving personal liberty, the High Courts are not exercising their jurisdiction as constitutional courts. So this is also Supreme Court has highlighted that even the High Courts are not exercising their constitutional power under the Article 226. So this is the context in which the Supreme Court has talked about. Now let's try to see what is actually provided in the Article 226. So Article 226 of the Constitution empower a High Court to issue writs including habeas corpus, mandamus, certiorari, prohibition and quo warranto. So we did discuss about all these writs. So these writs could be issued either by the Supreme Court as well as by the High Court for the enforcement of the fundamental rights of the citizen and for any other purpose. Now you have to remember that Article 226 talk about for any other purpose also. This phrase refers to the enforcement of the ordinary legal right. What does it actually mean? It implies that the writ jurisdiction of High Court is wider than that of Supreme Court. Why? The Supreme Court could only issue writ when there is a violation of fundamental right. But on the other hand, High Court can go ahead and issue writs even in the cases where the ordinary legal right is being violated. So in that regard, the jurisdiction of High Court is actually wider as compared to the Supreme Court. So the High Court can issue writs to any person, authority and government, not only within its territorial jurisdiction but also outside its territorial jurisdiction if the cause of action arises within its territorial jurisdiction. What does this basically means? Like for an example, take an example of Allahabad High Court. So what happened over there is that it's not only that the cases which is like within its territorial boundary, for an example UP, that it can only hear the cases about that. But even if the cases which has arise from there, or the person who is convicted is actually of the Uttar Pradesh, and they have been caught by the police, for an example in Madhya Pradesh, in that case also High Court has the power to issue writs. So it is not only the territorial jurisdiction, it can also issue writs outside the territorial jurisdiction if the cause of action arises in its territory. So this is the major power which is conferred to the High Court under the Article 226. So I hope you have understood this video. So we did discuss about the writ issuing power of Supreme Court as well as High Court, as well as the latest cases in which the Supreme Court is now discouraging the use of Article 32. So I hope you have liked this video. If you have any doubt, feel free to drop a comment. Thank you.